Hi, we're speaking today with Guy Gibbons, CEO of Bennett Carroll solicitors. Hi Guy.
Hi.
Well, we've got some legislation changes in relation to pool safety. Can you bring us up to date on that at all?
Okay, in late 2011 the Queensland Government upspec'd the existing rules to do with pools and pool fencing where residential properties are sold. So now it's a much tighter regime. There are much more specific obligations on sellers who sell properties that have pools in the backyard. First of all, there's an obligation now, which is written into the contract, for the seller to advise the buyer whether the pool is compliant with present legislation. Now there is a compliance certificate regime in Queensland for pools, so that you can get a certificate from an independent inspector which says, yes, this pool complies. So the contract requires the seller to say to the buyer that the pool complies or it doesn't comply. Now, if that's written into the contract that it doesn't comply, or if that's blank in the contract itself, then the buyer has an opportunity to go and get an inspection. The buyer has to pay for that, but the buyer can get an inspector to come and certify whether the pool is compliant or not compliant. If the pool is not compliant, then the buyer has the opportunity to walk away from the contract and get the deposit back. The buyer must be noticed by the deadline specified in the contract. So that deadline has to be put in there. If you're a buyer, you need to make sure that this pool section is filled in and that it has that deadline in it. If the buyer lets that deadline go, lets it expire and doesn't say anything, doesn't terminate, then it's open to the seller in that situation to say, right, you haven't notified me, I want out of this contract, and to terminate. But either party can rectify the situation. So at any time between the signing of the contract and the completion date, if one party or the other gets a compliance certificate that says, yes, this fence is now compliant, this pool is now compliant. It's not just about the fence. If either party gets a certificate between signing of the contract and completion, then whatever deadlines have been missed and whatever rights might have existed, those rights are extinguished, and it's as though everything was done correctly right from the start. So there is a chance to stitch up that hole.
Okay, so if I'm a buyer and that certificate hasn't been provided to me by the day of settlement, I can still terminate?
Yes, you can. Obviously the message for sellers who want their properties to settle is go and get a certificate and have it available at the time that the contract is being signed, so that it's just not an issue. But for buyers, yes, if there is a pool on the property and if you haven't been provided with a certificate, or if you've organised your own inspection and the inspector says, well, no, this pool isn't compliant, and they'll usually list a list of issues that need to be rectified. If that's not rectified by settlement and no certificate has been issued to you or provided by the seller, you can kill off the contract, get your deposit back, and maybe go back and negotiate a different price or different terms. It's not necessarily the case that you'll walk away from the whole thing and go and buy another property. You might still be interested in the property, but just at a different price or on different terms. So there's a chance to go back and start again.
Okay, well if we need some more information, where can we contact you?
Okay, well you can ring the office on 1300 334 566. You can go to the website, which is bcglaw.com. We're on YouTube. There's a heap of information on YouTube or on our website, or you can email us at info@bcglaw.com.
Okay, great. Thank you very much.
Thank you.
Okay. One more. Hi, speaking with Guy Gibbons, CEO of Bennett Carroll solicitors. Hi Guy.
Hi.
Now, I've got a lot of people buying and selling properties at the moment, but some of them may not be sure on what the actual settlement process is on the day. Can you give us a rundown?
Sure. Settlement day is pretty fraught. Funnily enough, most people just ignore the lawyers and proceed as though they're going to move house anyway. It's actually not a bad idea. Very occasionally we see people caught with a removalist standing on the footpath wondering what's going on. But the logistics of moving on settlement day, many people have to be out of their existing property, so they might as well do the move in one go. The logistics are such that you really have to plan for the day and just go do it. And the lawyers will stitch up the logistics if there's some kind of problem on the day. It does happen. Effectively, moving into the property means a whole range of things. Obviously, your financier needs to be ready, and everything that they require must be handed to them. Your solicitor doing the conveyance must be ready. All the figures need to be correctly calculated and agreed. The checks need to be agreed and handed to the advancing bank if you're a buyer of your bank that brings the checks along. You may in fact have to make up the difference. The bank might only be advancing you, say, 90% of the purchase price, and you have to make up the difference. So your solicitor should have said to you at least 36 hours earlier, these are the figures, these are the adjustments, this is the amount that your bank is giving you after all of their fees have been taken out of. Be careful with that. Sometimes it might be a $400,000 advance, but it might be $398,562 that you get. So you've got to watch out for that. And your solicitor should have done all these calculations for you, checked with your bank what the net figure was going to be, and said to you, this is your contribution. The next thing you have to be careful of is this expression, cleared funds. It does happen occasionally where a client will provide their contribution to the purchase price, but then the bank says, oh no, it'll be 3 days to clear that, which throws everything into chaos, of course. So you've got to check that when you transfer those funds, it's in cleared funds. Speak with your solicitor about how that's done. You can't really trust the counter jockey at the bank to say, oh yes, it'll be cleared funds. Just be certain of that. Simple things like utilities, telephone, electricity, water, all need to be done several days in advance. People talk about switching over the electricity, but the technical reality is that the electricity is switched off from the previous owner and reconnected for you. So it's a two-step process. They need to do their part, you need to do yours. It's a certain amount of liaison and lead time there. Telephone is the same. So that needs to be done. Your settlement will generally be from late morning to mid-afternoon to allow time for checks to be banked and for the settlement to go off. But obviously, as a buyer or a seller, your settlement day is a big long day. So you need to be organised. But it may be that you don't get the call from your solicitor that the thing has settled until 3:30, 4 o'clock in the afternoon. That's why I say most people just ignore the lawyers and get on with all the logistics of moving their stuff. Occasionally it goes haywire, of course, and you need to make short-term plans.
Okay, now I don't have to be there on the day?
No. Generally what we say to clients is, look, be available. Don't try and move house on the busiest day of your working year. Don't try and move house when you're doing an important board presentation on the other side of the country. Try and make time available. But generally, no, you don't have to be at the settlement. Your solicitor should take care of that and leave you free to actually do the logistics of the move. That is, be out of your old place, wherever that is, and be into your new place if that's where you have to stay for the night. And that's a pretty good task in itself.
Yeah. Well, thank you very much for the information, guys. If we need anything else, where can we contact you?
Okay, so you can call us on 1300 334 566. You can go to our website, which is bcglaw.com. You can email us at info@bcglaw.com, or go to the web. There's a heap of information on our YouTube channel.
Okay, thank you very much.
Pleasure.